Hello, you're watching BBC News with Joanna Gosling. An update on our headlines at 12:31. A South African court has dismissed the murder case against Dewani. He was accused of hiring hitmen to kill his bride Annie on their honeymoon. Her family wanted the trial to continue.
The knowledge of not ever knowing what happened to my dearest little sister on the 13th of November 2010. That's gonna haunt me, my family, my brother, my parents, for the rest of our lives.
Downing Street says it will seriously consider a cross-party parliamentary report on food poverty, which blames the slow payment of benefits for an increase in the number of people using food banks. The Court of Appeal rules that bus companies are not legally required to force parents with buggies to make room for wheelchair users in designated bays. A 25-year-old British base jumper dies after falling 300 feet from a cliff in Australia. The Duke and Duchess of Cambridge are in New York at the start of a three-day tour of the US. Prince William is due to meet President Obama to discuss the effects of illegal animal poaching. Now, let's get more on that decision by a judge in South Africa to dismiss the murder case against the British businessman Dewani, accused of arranging the killing of his bride Annie. Judge Jeanette Traverso said the evidence of the chief prosecution witness was riddled with contradictions. Shrien and Annie Dewani were on their honeymoon in South Africa in November 2010 when Annie was murdered. Their car was ambushed during a visit to a township on the outskirts of Cape Town. 4 weeks later, on the 7th of December, Shrien Dewani was arrested in Bristol under a South African arrest warrant, accused of conspiring to murder his wife. 2 years later, in December 2012, Kolile Mngeni became the third South African man to be jailed over her murder. In April this year, Shrien Dewani, after treatment for severe post-traumatic stress, was extradited to South Africa to stand trial. After a 2-month hearing, Judge Jeanette Traverso dismissed the case against Mr. Dewani, saying the evidence against him was improbable and full of mistakes, lies and inconsistencies. Nathi Nkube, a spokesman for the South Africa's National Prosecuting Authority, spoke to our correspondent Andrew Plant earlier and gave his reaction to the decision to acquit Shrien Dewani.
Well, it's a disappointment. We are very much disappointed with the outcome, but I think I must hasten to point out that we respect the decision by the judge. Look, it was always going to be a challenge for us. We ideally, when we deal with a matter like this, we want to have all the conspirators and all the people that have involved themselves in the commission of the crime tried together. And the fact that that did not happen, was always going to be a challenge. But also the fact that we were relying on the evidence of those 3 people who themselves had been convicted and also were incriminated in the offence itself. So that was always going to be a challenge.
There was a huge fight to have Shrien Dewani extradited from the UK here. It took 3.5 years.
Yes.
It cost an awful lot of money too to have him flown over from the UK. Are you disappointed then at the quality of the evidence, first of all, over those 7 weeks, and then by the judge's decision just to throw it out today because it just wasn't strong enough?
Look, as I said, we respect the judge's decision today. It is our responsibility, in fact, to emphasize and point out to people that there is a need to respect the judges. We must respect their decisions, and if we're not satisfied with them, of course, there are avenues within the confines of the law that we can engage in and take the matter forward. But unfortunately, in this matter, we do not have such an option. It is the end of the matter because, as the state, we can only take the matter further if, there was an error in a question of law and how the law itself was interpreted. And this application was merely focused on a question of fact. So therefore, it's the end of it, as it were. So but of course, also I must say that when we take matters to court, we only base that decision on the evidence that is available. It should be sufficient and credible at the time that we consider it, not at the time when it's delivered, because people get to see the evidence when people testify. We consider it prior to that, and we must satisfy ourselves that there is a case to take to court, and that's what we did. The costs do not play a role. If we were to prosecute people on the basis of how much it's going to cost us, you will have too few cases that will take to court.
Now, your 2 main witnesses, Zola Tongo and Mzwamba Dodekwabe, both of those people were given plea bargains, reduced sentences, in exchange for their testimony against Shri and Dewani. Well, now you've heard that it was all lies. So what happens to those plea bargains now?
Well, they stand. They have been convicted. They pleaded guilty. They are serving sentence. So we're satisfied with that. In fact, we are saying that, we have 3 people that have been convicted, who participated in this commission of this crime. So that on its own, it goes to show that, there was evidence that was there. As I said, due to the time lapse, which is 4 years later, you're trying to prosecute a person, based on the evidence that is given by the conspirators, was always going to be a challenge.
And just to be very clear, there is no opportunity to appeal this decision. That's the end of the matter. Shri and Dewani is free.
That is correct. Unfortunately, in terms of the South African law, the state can only appeal on a question of law. And as I said, you were in court, you had what the judge had to consider was the evidence of those witnesses, and the judge was of the view that, it could not be safely relied upon, and therefore, because it was inconsistent, there were a lot of contradictions, and therefore she felt that she needed to grant that application.
A High Court judge has ruled that the government's plan to close the Independent Living Fund is lawful. The fund catered for people with a disability claiming benefits. Well, let's go to our correspondent Daniel Bircher, who's outside the court. Daniel, tell us more about what the fund actually was for, what it was doing, and what this case is centred on.
Well, the Independent Living Fund has been in existence since 1988. At the moment, it provides support for around 18,000 people with severe disabilities. The government announced in 2012 that it planned to close this fund, to move the budget to local authorities and devolved administrations. It argues that that is a better way to provide targeted funding, but campaigners say that this money will not be ring-fenced. It could be spent on other things, and they fear that they will lose essential funding. This has been through the courts once already. On that occasion,